Attorney General, the former Attorney General has filed on behalf of Honorable Assafuah. Today you notice that even injunction, they had 2 injunctions on the record. And when they were asked, they quickly withdrew one and allowed the other, which is clearly an abuse of the court process to keep filing processes with the hope that one of them will stand. There's really not a good practice for a lawyer to do, and that is what happened. Decisions of the court really confirms what we have been saying all this while, that there is no legitimate, legal, constitutional basis for all these processes that the former Attorney General has filed on behalf of Honorable Assafuah. Today you notice that even injunction, they had 2 injunctions on the record. And when they were asked, they quickly withdrew one and allowed the other, which is clearly an abuse of the court process to keep filing processes with the hope that one of them will stand. There's really not a good practice for a lawyer to do, and that is what happened.
The producer is of this country. We've never seen any development like that before. Whenever there's a dispute as to the state of the Chief Justice in this country, start from 1980 to
The best in the morning is on 92.7 Sunrise on 3FM.
They're about the Chief Justice in person and panel the court, but never sat on the matter. I mean, so it cannot be right for the acting Chief Justice to sit on the matter. But that's it. We see the 3-2 ruling, very narrow decision. We'll wait for the reasons.
To fall versus Attorney General clearly tells you that in reading the Constitution, you have to do so by the letter and the spirit. If anybody tells you that because something has not been clearly stated in the Constitution, and for that matter, it has no potency, I am telling you that that is not the case. To fall versus Attorney General clearly tells you that in reading the Constitution, you have to do so by the letter and the spirit. If anybody tells you that because something has not been clearly stated in the Constitution, and for that matter, it has no potency, I am telling you that that is not the case.
3FM Sunrise.
The best in the morning is on 92.7 Sunrise on 3FM.
Those were back-to-back the Deputy Attorney General, Dr. Edrem Sremsai. After him was the former Attorney General of the Republic, Godfred Yeboah-Dame. And the voice you just heard is that of Echo Vincent Assafuah, Esquire. He's the Honorable Member of Parliament for the people of Otafo. Yesterday in court, there was quite a showdown, if you will. I'm not sure that the Honorable former Attorney General and his clients, Godfred Yeboah-Dame, saw the change in the panel happening, the panel that was supposed to hear them. Earlier, we had Justice Henrietta Mensah-Bonsu, Justice Yaw Asare-Darko, Justice Samuel Esiedu, also Justice Richard Ejay Frimpong, and Justice Ernest Geu. They were the ones who had heard the previous matter. And then yesterday, the acting Chief Justice reconstituted the panel. Of course, he's the president of the bench, the Supreme Court bench. He reconstituted the panel. So he himself found himself in court yesterday. That's Justice Paul Bafuboni. And then he maintained Justice Henrietta Mensah-Bonsu out there. Substituted Justice Yaw Asare-Darko with Justice Yoni Kulendi. And then substituted also Justice Samuel Esiedu with Justice Amadou Tanko, and of course substituted Justice Richard Ejay Frimpong with himself. So once he's on the bench, he then presides because he's the Chief Justice and the senior most, as it were. Even if he wasn't the senior most at the time, he still will be the Chief Justice, so he would preside. So this was the panel that had, and then 3-2 in favor of the motion. Ellen, maybe you help us. The petition seeking removal of the Chief Justice. The Echo Vincent Assafuah had gone to court to say, look, I disagree, but there are other petitions as well before the court, right?
All right.
The injunctions, I should put it that way.
All right.
What did they say?
All right, so these are injunction applications and how the Supreme Court dealt with them. Vincent Echo Assafuah versus AG filed March 27th. struck out as withdrawn. Then you've got Ebenezer Osei Owusu versus the AG, filed on the same day, March 27th, also struck out as withdrawn. So Johnny, is it that the case, they were struck out, they were withdrawn and subsequently struck out for that reason? Struck out as withdrawn.
Well, once you withdraw, it will be struck out, because if
you've withdrawn.
Yes, you are not pushing forward your issues anymore. You
are no
came to
longer
the court to say
interested.
that this is happening. You are not happy about it. You want to injunct it. You want to stop it. And then you come to the court to say, okay, look, I've withdrawn the injunction that I intend to pursue. The court to say, okay, once you have withdrawn, then let's strike it out of our books.
And then we've got Vincent Assafuah versus AG, filed on April 24th. Now, that one, he did not withdraw, but it was dismissed by a 3-2 majority.
And 3-2 majority means that 3 of the judges on the bench decided that, well, we are not in support of it. 2 of the judges decided that, yes, we are in support of it. Of course, Justice Paul Bafo-Boni, we are told, is part of the 3 that said yes. Justice Unikulendi is part of the 3 that said yes. And then Justice Amadou Tanko is part of the 3 that said yes. Justice Henrietta Mensah-Bonsu and Justice Yehu, NSJU says no. We think that the petition or the injunction should have been upheld. The reasoning will be out on the 21st of May, that is. But we know that sometime this week, if not today, Her Ladyship, the Chief Justice, will appear before the Justice Poaman Committee to be heard. It will be heard in camera, so we will not get the benefit of what will be said in that room. However, there are those who are proposing that the whole, proceedings, or entire proceedings be televised.
That's right.
But that will be contrary to what the Constitution says. The Constitution says it should be held in camera.
Proponents of that idea are suggesting that the CJ should just waive that right to for a discrete procedure. Again, that's not in the Constitution. I don't know whether that can be considered.
Right.
And so they say, if she says, well, it's my matter, I'm the one under scrutiny, this is my hearing, as it were, and I want it to be televised. Those are what the proponents are suggesting, that she do waive that right, or waive that constitutional provision that says this is done in camera. I don't know how that would work.
Does it lie in the mouth of the Chief Justice, who is now on suspension, to say that? It doesn't lie in the mouth. I think that it's the framers of the Constitution, in their thinking, thought that it will preserve the sanctity of the institution called the judiciary.
That's right.
So it is not about an individual's whims and caprices, because all through the process that we have, it has never been about an individual. It is about Madame Gertrude Torkonoo being the Chief Justice, and in that position, people thinking that she may have done 1 or 2 things that is not right by the rules. It is not about her individual personality. It is about the role of the Chief Justice and who fills that role. That's one. John Dramani Mahama referred the petitions to the Council of State, not in his capacity as John Dramani Mahama, because if it were John Dramani Mahama living in his house on the Spintex Road or the Airport Hills or wherever it is, I'm not sure anybody would have gone to give him any petition to see him. He is there acting in that capacity as President of the Republic. Anybody else on the Supreme Court bench or in the Council of State are all acting in their professional, or, if you like, original capacities. They are not acting as individuals. So those who are proposing that, I may find it a bit problematic, because it is, first of all, to preserve the sanctity of the institution called the judiciary, not an individual.
They also add on to that request, or that idea.
Sorry, but can you imagine if this is televised and, things get heated up, things are said to each other, and then Her Ladyship, the Chief Justice, is not found guilty of anything, and she's asked to come and continue her work? Can you imagine how people will be looking at her from outside? I mean, if you're appearing before her, a certain prejudicial mind that will preoccupy your head. It's for the protection of the institution.
I agree with that.
For those who want it televised, what's the reason why they want to televise? Is it because they, number one, they want to know what happens, or number two,
I'm sure they have doubts.
Yes, so they don't trust the happenings during the committee. If that is the case, if they don't trust it, then how did we arrive at this point? And then how would we solve it? So if if the committee hearings happen, should we expect, communication from both parties? If maybe the committee would release a report, a statement to say that A, B, C, D, because of this, the Chief Justice should go, the suspended Chief Justice should go. If the Chief Justice feels she has been hard done, then she also comes to say her side of the story.
Right.
Then we're getting somewhere. We're getting to know what really happened. But to call for it to be televised when a lot of things could go wrong, a lot of things could also go right. Like you're mentioning, if tempers flare, if there are sensitive revelations about Ghana's judiciary, it's not good for all of us to get to know. Then we'll lose a lot of trust.
I'm even saying that, look, we're getting to the point where this whole process is supposed to be in camera, it's supposed to be a matter of secret, right? Now, you have people claiming on the streets that, I've seen the petitions, I've read the petitions, I've read the responses. And you ask yourself, how did they come by them? I've seen some purported copies of the petition. I have not bothered to read them.
Why is that?
Because it is not my business to know what is in there.
Because a lot of the time, what is out there may not be
necessarily spending maybe 20, 30 minutes, 1 hour of my life reading
a fake document.
Fake document or special nonsense.
Or counting fake money.
I don't want to be in that situation. I think that I believe in the institutions of state that we have, and sometimes you also think that, okay, why the swift change? Because there were people who believed so much in the institutions of state not so long ago. Under 6 months ago, they believed so much in the institutions of state. What changed? Because the institutions remain the institution. There are some persons in there who still remain within the institution and based upon which they had trust. That has not changed. So why now? What really has changed within this short period of time that we cannot trust the institutions so much that we want everything to be out there in the public domain? Mind you, once you start showing it live on television, websites will stream it, online platforms will stream it. It will not stay in the jurisdiction of Ghana. It's going everywhere.
Everywhere. People are allowed to make comments, as they watch the stream. Can you imagine?
Your Chief Justice now becomes literally, for want of a better expression, naked before the whole world. And that kind of aura and the respect and the reverence that comes up. You meet a judge and you are very careful, how many of us even get an opportunity to meet a judge? Some people's first experience with a judge is when they enter a courtroom and the judge is up there and they are down here.
Yeah.
Right? That's the only experience they may have with a judge. Some are fortunate to be relatives with them, so they get to see them at functions. Some are fortunate to be bankers of judges and all of that. I mean, people have privileged relationships with judges. But then for you to put a Chief Justice out there and have another member of the bench or two senior members of the bench down here firing questions and asking questions, what you are seeking to preserve is now then destroyed. I'd rather have that they do that in camera.
I agree.
Do whatever they want to do and come up with a nice report, even if it's whitewashed. Come up with a nice report that they all agree to say that, okay, we are going left, we are going right.
To preserve the
sanctity of the institution.
If you don't do it like that, the spins that people will put on during commentary could be very, very dangerous.
Very dangerous.
It may be not close at all, but because they're using, number one, lay understanding, number two, personal interest, they put various spins, various interpretations, and then they'll push it so far that may even plug the minds of many who originally had good intentions, but because they've been exposed to lies or fake news, then they believe it, and it is also affecting the integrity of the judiciary.
But gentlemen, so far in this process, I'd say maybe one or two things have gone a step further. So the president even furnishing the CJ with copies of the petition is not exactly written in our constitution. Right. Would you say that he's gone out on a limb to, I don't know, to go that extra mile? That may have opened Pandora's box, and one might say that if we've already started on the path of adding extras which are not streamlined with the Constitution,
aimed at making the process fair.
Making the process fair.
enough.
Then, if Mr. President, you've gone that step, then let's keep going, because now we've opened it wide open.
You see, I'm reminded of the dictates of Article 296, which talks about the discretionary powers and the use of discretionary powers. If you notice, the Chief Justice asks for 7 days to respond to the petition. The President of the day says, look, take 10 days, add 3 more days, feel free. I don't want to be seen as, I'm sure, he didn't say that expressly, but I'm sure that the wisdom behind it is that I don't want to be seen as the person who is breathing down your neck to say, give me your response and do all of this. That's one. Number 2, you have been accused. It is only fair that you are given an opportunity to come and explain yourself, right? So that your accuser can stand before you and you before your accuser, and then you can both be heard. And then whoever is the arbiter will then decide that, oh, Helen is blowing this out of proportion, or Crosby is the one not forthcoming with information for us to, so that level of fairness, that principle we're taught in the journalism school, auditorium patem, it should be there. It should be laid bare. For me, I think that there's a limit to the powers of discretion, because even within that 296, and I'm not a lawyer, but even within that 296, Article 296 of the Constitution, it talks about whimsical, capricious, you need to be careful how you apply the, what's the word? Discretion, the use of discretion. You get the point. So, yes, there may be discretion on the part of the president, there may be discretion on the part of the CJ, but I don't think it ventures into the corner to say, let us put this on TV. I am saying from a layman's point of view, if we put this on TV, the judiciary that we say we seek to preserve will be crushed. It will be crushed, because now when the matter becomes public, people will ask, okay, so who is the CJ's husband, and what does he do, and what does he eat, and where does he live, and why did he take that? What did he use the $10,000 for? And who is the CJ's daughter? Thus far, not many people know who the CJ's husband is. Not many people know who the CJ's daughter is. Now you are going to expose them out there. They don't have bodyguards like the CJ.
That's right.
So, what are you doing? The ripple effect of a certain decision that seems to inure to a political beneficial end may come back to hurt all of us, and it will hurt us deeply, because once you televise this, it's global. Everybody in every corner who has internet can see it. Like we put for the first time, Chief of Defense Staff in court for the first time in the history of Ghana. A Chief of Defense Staff, a 3-star general, standing in open court and defending a document that doesn't exist. Can you imagine? Have you seen some before? Lawyer Osman Alasan is joining us. He is a private legal practitioner. Counsel, good morning. Thank you very much indeed for your time.
Good morning, and good morning to your listeners.
Social media, traditional media, and the social sphere have all been talking about the decision that the Supreme Court took yesterday regarding the injunction applications brought before it relative to the petitions for the removal of the Chief Justice Leadership Torkonoo. Were you surprised with the decision of the court?
Well, I was surprised not by the ultimate decision, but by the aggregation of the judges' support and rejection of the decision. It was 3-2, right?
Mm-hmm. That's right.
Yes, my surprise was what the two has to offer in defense of their decision. I am interested in reading what the two dissenting judges have to offer.
We would have to wait until the 21st of May to get that reasoning.
Yeah, so that is the only aspect of surprise, because I thought, and I believe if there is any decision that can be unanimous, this should have been. This should have been a unanimous decision, because what's an injunction? An injunction is always an application to hold off, to hold off certain things from happening, or to maintain the status quo until something substantive is decided upon.
Right.
So, what's the substance? What's the main dispute? That they intend to hold off all proceedings under Article 146 until it is decided. What is that dispute? Now, that dispute seems to be that the president do not give or fail to give the Chief Justice a hearing. But is that the case? So if you don't have a substantive matter to be decided, you can't be applying for injunction. That's number one. So number two, the injunction was supposed to hold off a constitutional duty that the president and other stakeholders in the process are performing. Now, there's no court. We all know that the Constitution is the supreme law of the land.
That's right.
And the obligations under the Constitution are the highest, the most sanctified obligations. You know, so no court decision can hold off the performance of a constitutional obligation.
Right.
Now, the constitutional obligation is even for the president. And now, if you look at our Article 57, I think clause 4 or so, you know, the tendency of that application cannot hold off the proceedings, one. And the injunction that they are seeking is seeking to actually stop what the Constitution says the president should do. And that would be against the oath of the president. You know, if you look at the Constitution, the preamble, and you look at the various oaths of office, now each one of them, including the Chief Justice and the judges, swear to us as people that they will uphold, preserve, and protect the Constitution.
Right.
What does that mean? It means that anything that the Constitution wants done is the highest thing that the judges, the executive, and the legislature must protect. So it is not in the place of the judiciary to stop a clear constitutional function. And so for me, the surprise of the decision, you asked whether I'm surprised, yes.
That's right.
The surprise of the decision is what the dissenting judges really will base their dissenting on. I really want to see that.
Great.
And I was surprised that there were 2 judges out of the 5 who actually dissented. But be that as it may, knowledge is wide. we want to see the argument, the reasoning behind the dissenting judge's decision.
Very well. Now, what does this decision of the Supreme Court mean? Now, the 2 petitions or 2 injunctions have been withdrawn. One has been struck out by a 3-2 majority decision. What does it mean going forward for the processes that have already been set in motion per Article 146 of the Constitution?
It just means that the process will go as normal as it has been. As we always say in legal parlance, it takes its normal course. So the committee set up to do a further inquiry of the matter will proceed with the inquiry and give us the outcome of their findings, their reports, and their recommendations to the president.
What do you think of a public show of the proceedings? Some of the view that let's televise this, let's show it to the world so that we know that everything is fair and nobody is trying to muzzle anybody into a corner. What do you say?
No, I think that as I said earlier on this program, on this station, there is always a reason for why the proceedings are to be in camera or confidential, because there are prejudices that can be provoked within people who do not have knowledge of legal process. If the procedure or if the allegations and the procedure is open to the public, they can come to prejudicial determinations of things that are actually defended. And so if the Chief Justice gets absolved at the end of the day, it will still remain a scandal in the mind of people about what is going on. Though it appears that the constitutional intention in this regard is somewhat defeated by what people we find in stipulation, whether true or false, representing the allegations in the petitions and the proceedings. I don't know how people get to know them and then get them out. But for me, I think it should be confidential. Now, number two, even if we all agree that it shouldn't be confidential, it should be something public so that we are privy to what the committee of inquiry is doing and whether the proceedings are fair against the Chief Justice or otherwise. Then we have to rather be advocating for a constitutional amendment, because at the moment, there's no way you can interpret Article 146, Clause 8, I guess, to mean that some part of the proceedings under Article 146 must be public. Because the Constitution is clear, it states in no uncertain terms that the proceedings, the whole proceedings under Article 146 must be confidential. So if we agree that it shouldn't, then we rather have to be talking about amendment of the Constitution, amendment of Article 146, so that we don't do things inconsistently with express provision of the Constitution and think that that is the spirit of the Constitution. No, that's not it. For me, there must be an amendment to Article 146 before anything contrary to Article 146, Clause 8 can be done.
Now, again, there are those who say if we don't stop this process and we continue with this process, we will be attacking the judiciary and breaking it down. I'm sure you followed the demonstration of the minority and some other interested parties.
Yeah, I get you. But why do people argue like that? Why do people argue like that? That if the Constitution makes provision for the removal of somebody, an officer, then it means it is an attack on the independence of that authority. In all the organs of government, that are established by the Constitution also provides the means by which they can be out. And that is supposed to be providing an avenue for accountability. And the judiciary is not an exception. The judiciary is established by the Constitution, and the Constitution makes provisions for removal of judges, Superior Court judges, and the Chief Justice. So how can anybody interpret the removal process to be an attack on the judiciary? I don't get it. So it means that the constitutional to Article 146 is an affront to judicial independence. Is that what they are saying? Because if the argument is that, okay, the conditions stated at Article 146 are not met, and so what is going on is unconstitutional, that would be a different argument. But they are not attacking anything done unconstitutional or inconsistent with Article 146. They are saying that the mere fact that the Chief Justice is being suspended and the proceedings, an inquiry is being made according to the Constitution for allegations against her, it means it's an attack on the judiciary. So if an impeachment of the president starts today in Parliament, is it an affront to the executive? If the speaker is being removed,
right,
or a suit is initiated in the High Court for the removal of the speaker,
right,
is Parliament or legislature being undermined? I mean, it doesn't make sense to me. The argument should have been that, what the allegations are do not meet the threshold for this to be done. But nobody can say that, because for me, I still believe that the allegations and the proceedings are confidential. I don't know for sure. And I don't know whether what is in circulation is an actual and exact representation of what was presented to the president and the committee. And so no one can actually say that, the allegations, the prima facie determination, and all that is unconstitutional. Not yet. And even if we have to take into account what is in circulation, for me, if I were to be an independent, I'll find a prima facie determination. And if I find a prima facie determination, it doesn't mean the Chief Justice is going to be removed. It just means that, it calls for, it makes a case for her to answer. That's all. And if she answers the case appropriately, then she remains in her office. How is this an affront? How is this an attack on the independence of the judiciary?
If you were to advise the presidency or the executive, they received the petition, the judiciary themselves received the petition, and Parliament received the petition, 3 arms of government from the demonstrators regarding this matter. And they have stated clearly in it the things that you find surprising that somebody would debate along those lines. In effect, what should they be doing with the petitions?
Well, they have received it as part of our democratic advancement. The demonstration was allowed. The officials for whom the petitions were meant availed themselves and received the petitions. That is democratic. That is beautiful. And it's for them to now consider the content of the petition. Of course, if the petition is calling for lawlessness, is calling for unconstitutionalism, of course, it has to be ignored and actually disregarded with all the disdain that it deserves. Because, I don't know the content of the petition. I don't know what they are asking the president, the legislature, and the judiciary to do. But if, in fact, they are saying that the whole procedure under Article 146 against the Chief Justice must be stopped, then that is treasonable. That is an indirect call for a suspension of Article 146, unless they are saying that something in Article 146 is breached, and so because of the breach, it has to be remedied by way of the suspension or something. But that's not what I think is the case.
Right.
They are not alleging that anything is wrong. In fact, what I think we discussed this last week.
That's right.
The last time.
That's right.
The point is that they are saying that the injunction. We are simply saying that the discretionary power under Article 296 exercised by the president is unconstitutional. Why? That there are no rules and regulations set in place to govern the exercise of that discretion. Is that why the procedure must stop? What about the other judges who have been removed, Superior Court judges who have been removed through that process? Have there been any rules and regulations? And the existence or otherwise of the regulations that govern the exercise of the discretion does not make the exercise of the discretion unconstitutional. It is clear the Supreme Court itself has come to that determination in several cases, that yes, any authority who is conferred with discretionary power must come out with regulations except the judiciary or judges. But the Supreme Court said, yes, that is to advance accountability and fairness.
Right.
But the point is that in the absence of those regulations, imagine the day the Constitution was promulgated. All the discretionary power had been conferred.
Right.
So it means that on that day, when it is impossible for all regulations to be laid and passed to govern the exercise of the discretion contained in the Constitution promulgated in 1993, so government will come to a halt. No one will exercise a discretion. And if we go by that, it means all the discretionary power exercised on the day of the promulgation and further. And those that do not have rules and regulations governing their exercise now should be unconstitutional. And anybody who is aggrieved under the circumstances must have his situation reversed. That's not it.
I see.
So I don't know what the argument is about. And if indeed there is no any argument against the proceeding in Article 146, nothing unconstitutional about it, why should they be demonstrating in the first place? And the fact is that they have a feeling that the judiciary, the Chief Justice, is too big to be removed. And you will hear some people saying that Article 146 is just for the optics. It's not supposed to be applied in respect of Chief Justice. How can we think like that?
Well,
so we are not worried of the fact that we can also create a judicial tyrant. There is something we call judicial tyranny.
Right.
If you have a judiciary that cannot be held to account, I mean, let me tell you, it's only the judiciary. It's only apart from Article 146, you will not find any other, because the judiciary is protected. Right. You will not find any other person being empowered to question anything a judge does or the judiciary does. Apart from the Auditor General and Article 146, which would be a check on the attitude of the judiciary. The judiciary are not supposed to do anything they like and go away with it. No, they are subservient to the constitutional dictate and they are subservient to the will of the people. Okay. And if the Constitution makes provision for a removal of Chief Justice and it's been triggered and is moving on, and this is not the first time it has been done. It had been done before. People have exercised discretionary power under these circumstances and people have gone. Why should this be? Why are we now being made to understand that the procedure is an affront, and it appears that the whole of Article 146 in respect of the Chief Justice is an affront to judicial independence? And who grants the judicial independence? And this is not the same Constitution.
Thank you very much. Counsel Osman Al-Hassan is a private legal practitioner. We're grateful that you could join us this morning. Thank you so much. Helen, why do you argue like that? Why?
Some very interesting thoughts there from Osman Al-Hassan.
Why do you argue like that? Why?
What do you mean?
Why do you argue like that?
What have I argued about?
That the Chief Justice is a woman, so we should not remove her. Why do you argue like that?
I have not even plugged into that. You have not said
that. Okay.
I know some of our Christian moms had something to say about that. But regardless of the gender of the Chief Justice, as Osman Al-Hassan Esquire said in his closing thoughts, nobody's above the law. These safeguards are put in place so that democracy prevails.
You hear the likes of Vincent Assafuah who went to court, and many others talking about Alexander Penyomakin talking about retaliatory politics. You hear Vincent Assafuah suggesting that one or two things may have been done wrong in the past. Is that really an admission that they knew that they were doing wrong things, but they went ahead to do them anyway? And now, even before anything happens, constitutional or unconstitutional, they're already raising red flags.
Johnny, Chief was saying, "No trust no names in the church, but so who trust asano? That's when Crawford na wachi. That's one can't show up. When you say we church, so maybe
the one who is carving the path does not know that his back is crooked. But if you are carving the path and you have people standing behind you and they don't tell you that your path is crooked, that means that they know that your path is crooked.
They're just not minding. So That is what it means. That although the main leader, maybe the president may not have known, his followers, his appointees, his ministers were very much aware. Because they're admitting it right now. Why will you not admit it earlier, but come and say that, okay, some wrongs were done in the past, don't repeat the same. Where you are wronging it, you know that you are wronging. But it's good advice, though. If wrongs were done in the past, what is wrong yesterday is still wrong today.
What do you say to those who say Atika Tika Katipo? 1-1 draw.
It's children's play. It's not. it's
not nation building.
But it's a cautionary tale.
Yeah, Atika Tika Katipo.
It's a cautionary tale. You just have to test the mood and temperature of the nation to know that duty bearers have to be very cautious. What you do today will be waiting for you tomorrow.
Mind you, NDC will not be in power forever.
That's a fact.
Will definitely come one day. And then 2028 or maybe the 2032, the other years. If it happens, and if they also want to say, okay, because you did us this, it will do you this, then where are we going?
Anyway.